Sometimes judges get things right, and we have an example of that today in the Ali trial. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. So, an interesting issue developed in the Ali trial today regarding Mrs. Ali. I think her name is Zarha. And it has to do with pre arrest silence, which is different than voluntary statements made before arrest. As I've stated numerous times here on the channel, Miranda only applies if you are in custody. If you've been detained and somebody wants to ask you a question, Miranda applies. But if you're standing there and the cops are just trying to figure out what's going on, and they ask you what happened, and you say, well, I hit the guy with a poleaxe, sorry, it's a voluntary statement. You answered the question. And if later on you go, ha ha ha, you didn't Mirandize me, they'll go, ha ha ha, we didn't have you in custody. So this is an interesting set of argument here. And for once, I think the judge makes the right call here on this evidentiary issue. So let's take a listen, and then we'll listen to some of the testimony in terms of how it works out in the end. Before we get there, I need to set this up. There was an objection. The objection was sustained. The prosecutor asked to have the judge reconsider, so they adjourned outside the presence of the jury. And this is part of that argument on the objection.
Opinion. When a defendant does not remain silent and instead talks to police, the state may comment on what he does not say. Then it cites to Young, it cites to Osborne, which is vacated on other grounds. Behavior is also addressed as well. I let law enforcement, I let defense counsel know of an unpublished case as of recently as 2021, State versus Johnson, which restates the same thing. There is no infringement on the defendant's right to remain silent when they make statements to law enforcement, when they provide a version of events to law enforcement, and they actively do not provide other events to law enforcement. They don't make other statements to law enforcement, especially when one might expect them to make those statements. The rule does not require that questions are asked. The rule does not require that there are, in the case law, does not require that there are conflicting statements. Any of that is not part of the analysis. It is simply once they have waived their right to remain silent, that opens the door for what the parties can inquire about what was said, how it was said, and plainly what was not said. So in this case, you're right. I believe counsel is right. Officer Chavez did not specifically inquire about the status of Fatima, but what the officers did do is consistently ask everyone present, what's going on? Can you tell me what happened? Can you tell me what's going on? And the only information provided by Mrs. Ali as to those events was what Isaiah was doing to her husband. And she was adamant, and it was repeated over and over again. Not once did she mention what her husband is doing to her daughter. That is relevant, that is significant, and it specifically goes to the interest of Miss Ali during the course of these events. It is notable, too, I would say, to state that when we are talking about, it's not unfair, it is Mrs. Ali's statements. Mrs. Ali actively engaged, voluntarily engaged. She's not arrested. She is not in custody. It is not any part of any pre-arrest silence. She is voluntarily providing that information because she wants law enforcement to act in a certain way. When counsel argues, well, she was told she couldn't go to the school. She was also told that she couldn't go see her husband, and law enforcement had to continually intervene. She consistently declined to follow their directives.
Now, I think this is a pretty good argument, but of course, the other side gets an opportunity to offer their opinion as well.
The issue in Hager and Young is there's specific questions that they provided misleading answers to. And thus they're then cross-examined. They say, well, you had an opportunity to say this to this specific question, and you refused or provided a complete answer. This witness didn't interview my client and didn't say, I want a detailed description of what happened. He describes, that her husband was struck, but there was no discussion, there was no interview with this officer who was just beginning on the force. So it's leading to the jury to somehow say that it was incumbent upon my client to provide a narrative when not asked by Officer Chavez. And there's body-worn video, and they're not choosing to use it. That would, they're not pointing to a specific point. At this section, this is when she provided a misleading or conflicting answer or an incomplete answer. It's just that somehow she was supposed to volunteer information. I think that's the problem.
All right, thank you. There were 3 questions where there were objections. The first question was, and during the course of that, did she, and were questions to Officer Chavez related to interactions with Mrs. Ali, did she provide you a statement, meaning did she come to give you a statement? Objection sustained. I continue to sustain that objection. The next question was, during the course of your time with her, did she voluntarily speak with you? Response, yes. Mr. Leary objected. I sustained the objection. I no longer sustain that objection. I overrule that objection. And that question should be re-asked of the witness, and she will be able to answer that question, whether or not Mrs. Ali voluntarily spoke with her. If and we already actually know that she did because the officer has already testified to some of their interactions and some of the statements that Mrs. Ali made voluntarily to Officer Chavez. And these cases talk about when a defendant does not remain silent and instead talks to police. It doesn't say answers questions asked by the police. It says when they talk to the police, the state may comment on what the person does not say. And that by asking those questions, it is not commenting on a right to remain silent because the person has chosen not to remain silent, and instead has chosen to voluntarily speak with law enforcement. And so in that way, I am going to be overruling the objection and allowing the witness to answer questions. I do not find that violates Mrs. Ali's constitutional right to remain silent, does not violate really, the argument is the state commenting on a right to remain silent because she did not remain silent.
Again, a pretty good ruling, and one that goes directly through the case law and works to the advantage of the state here. And this is one of the reasons why it's so very important when people interact with the police to understand that everything they say, whether they've been Mirandized or not, everything they say can and will be used against them in a court of law. Now let's listen to a little bit of this testimony.
Officer Chavez, when we left off, I believe my question to you was, did Mrs. Ali come to voluntarily speak with you?
Yes.
And how would you describe her engagement in trying to provide you information? Meaning, eager, reluctant, something else?
She appeared eager.
Sustained.
How did she engage with you? How would you describe that engagement?
Her initial reaction to seeing me appearing on the scene was to approach me and begin to plead or beseech me.
Okay. And during that interaction, who was she expressing her concern for? When you say beseech you, about what? What does that mean?
Would you like me to tell you what she told me?
And ask questions.
I see.
That's okay.
When she initially made contact with me, she asked if I recognized her, confirmed that I knew who she was, and then stated that there had been people punching her husband.
And did she describe details about what that looked like?
She made the punching motions with her hand.
Okay. And throughout that interaction with her, who, if anyone, throughout the course of the entire interaction, who, if anyone, did she express primary concern for?
Could you restate the question?
Yeah, I'll rephrase that. When you interacted with Mrs. Ali, did she express concern for her husband?
Yes.
Did that seem important to her?
Yes.
During your interaction with Mrs. Ali, did she ask about the specific health of Fatima?
No.
Did she ever discuss the actions of her husband on Fatima during that period of time?
No.
And how much of your interaction with her was focused on her husband's condition and what Isaiah had done to her husband?
I would say that was her primary focus.
Thank you. I have no further questions.
Under the generalized heading of actions speak louder than words, this is a situation where her actions are speaking louder than her words do. She isn't concerned a whit about her daughter. All she knows is her husband, her meal ticket, has been beaten about the head and she doesn't like that. Never mind the fact that he was trying to strangle their daughter, a kid she carried around for 9 months inside of her. Apparently that doesn't strike her as problematic at all, and boy, doesn't that tell you something about Mrs. Ali. I'm going to leave it there. If you have any questions, drop them in the comments below. Otherwise, see you in the next one. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.